And tonight it's my pleasure to introduce Joe Rose, the principal of Rose Legal Costing. He's here to give us a bit of an update on our legal costing procedures and also to answer any questions that you have. And we've already had one start us off, so I'm sure there'll be plenty more. So handing over to you, Joe, and thanks for presenting.
Thanks very much, Jennifer, and hello everybody. I guess start by way of a bit of background to myself. I've been practicing legal costs for over a decade now, almost solely. So prior to setting up Rose Legal Costing, I was heading up the New South Wales office of Blackstone Legal Costing, and then prior to that, years before that, I was heading up the London office of Partners in Costs, which is a UK-based cost firm. So I've pretty much seen every area of law, pretty broad in terms of acting on behalf of paying party or receiving party. But I would say probably about 99% of the work I do is direct instructions from law firms, as opposed to dealing with lay clients. So you're probably all thinking, lucky you there, because I've seen many a time when it's difficult to get a client off the phone, it's difficult to focus their mind. So yeah, I don't envy you for doing that. That's enough about me and my firm. What I wanted to talk to you about today, obviously we've got a finite level of time. What I like to base these on primarily are really issues that are going to help practitioners kind of on the front line in their day-to-day work. Now, that's moving away from kind of going into the minutiae of cost case law, quoting 10 sentences. So some of you might think this is a little bit easy. I hope for the majority of you it will be a bit of an eye-opener in terms of just how it can assist you in relation to the cost assessment process if you ever do need to get there. How this is broken up, I think roughly the first third of my talk is going to be focusing almost solely on solicitor client assessments and what to look out for there. And then the last, I'd say, third to 2/3 will be more along the party lines. But of course, with regard to party cost assessments, there is still some relevance there in relation to the solicitor client assessments. So yeah, just going to be covering the basics of cost assessment, cost recovery, which again, as I say, will overlap the two, invoices and cost disclosure, which will almost solely be in relation to solicitor client costs. And then at the end of the slides, what I've included are my firm's last two matters in which we were instructed, and the outcomes that we got. So one was a determination from, I think it was September now, and the other was a review application, which I only received about 2.5 to 3 weeks ago. And we've actually filed yesterday an appeal to the Supreme Court on that matter. So it's very much a live process there. So hopefully that will give you some insight in relation to the assessment process, because one of the problems with the assessment process, and there are many benefits to it, but one of the main issues are the lack of reported cases. So I'm hoping that will assist you all in terms of just a better understanding of what to expect. So just a quick kind of broad breakdown of solicitor client and party proceedings. A lot of the time people don't like to make a differentiation, but I think for the practical side of things, it is easier just to use those two terms. Over the years in various jurisdictions, I've found that a lot of people expect to, on assessment, recover about 85% of their costs in solicitor client assessments, and then in party assessments, somewhere between 60 to 75%. Some law firms, and I wouldn't be surprised if some of the audience here today do this, actually include within their cost agreement, you may get a party cost order, and you may expect to receive X percentage of the costs. There may be marketing benefits to that, but I generally think it's not the best idea to do, because if you've got a studious client, they may, when you get to the end, have a cost order. If you've got kind of interlocutory cost orders that aren't in your favour, that obviously dwindle down that percentage somewhat, you might have a more difficult conversation with the client than what you otherwise would. And I see very, very broad ranges, particularly in regards to party-party assessments. So again, I'd use this as a very rough barometer, but certainly not as a kind of a what to expect in the majority of cases. So how to narrow the gap between those two percentages? Because obviously, if your client's paying 85% and you're only recovering somewhere between 60 to 75%, then the narrower the gap as possible is that results in a narrower payout for the client. Now, obviously, I'm only talking in relation to the contentious side of things, but this list of kind of do's and don'ts applies equally if you're in solicitor-client or party-party proceedings when you're time recording. And these just a list of things to try and avoid. So, for example, intra-office correspondence that are particularly procedural in nature. And again, as I alluded to earlier, assessors have differing opinions on this. Some, whenever they see an item in a bit of cost that is claiming for intra-office correspondence, they will say that that's unreasonable, but others will obviously allow it. That point and multiple solicitors in attendances at conference. My argument, the counter argument to that I often use when I'm acting on behalf of the receiving party is that although on the face of it would look like duplication of work, that allows for delegation of work. So, for example, if you've got in a conference of, I don't know, with counsel or anything like that, if you've got a partner and a graduate lawyer in attendance at that conference, what that allows you to do later on is to actually pass more work onto the graduate lawyer, who would in turn be claiming a lower hourly rate. So the overall reduction will be there, although it might seem, if you're looking at the conference in a vacuum, that there are more costs claimed for that item. So again, as I say, there's no hard and fast rule to this. The point in relation to travel time, it will always be reduced to half in party-party proceedings. If it's in your cost agreement and you've said to the client, I'm claiming full rate for travel time, if the cost agreement is valid, so if there's no arguments or should say issues in relation to cost disclosure, for example, then that travel time will be reasonable, unless it's obviously exorbitant. And just as a final point, again, in relation to supervision, that again, in my view, often goes back to the point of that allows for more delegation, so more work to be done by fee earners charging a lower hourly rate, which is a net gain for both the client and the other side if you do ultimately have a cost order. I forgot to say at the beginning, if you do have any questions as we go along, feel free to ask them. I'm hoping that, yeah, it's probably best to just shout them out as we go. So feel free to interrupt and I'll address them as we go. Obviously, I think if we start getting sort of a question every minute, I might kind of tailor that. But yeah, by all means, ask questions as we go along. So first point in relation to providing invoices to clients and the assessment procedure. First question you have to ask is whether or not this is a lump sum or an itemized invoice. I've been instructed in relation to a few cases where what has been sent out is somewhere in the middle. So a lump sum, a true lump sum invoice is just an invoice that's been sent to the client that has a total figure on it for work undertaken. It can be a breakdown in relation to disbursements, but in relation to the law firm's costs, it's just that one block figure. And then the itemized invoice is obviously a fully itemized breakdown of the work undertaken. What I often find is that what's sent out is somewhere in the middle, and that causes ambiguity, both in terms of the timeframes and also whether or not the bill is in accessible form. And if you've sent out a partially itemised invoice, an assessor will more often than not lean towards saying that he or she is able to assess it on the basis of the invoice provided. But if you've sent out an invoice that doesn't actually itemise all of the work undertaken, then obviously you're opening yourselves up to a higher reduction if you do get to an assessment. So my advice, and I haven't actually heard any other cost firms suggest this, but my advice is always to make it a binary question. So either send out a fully lump sum invoice or a fully itemised invoice. If you're doing something in between, then problems may arise. And then just quickly in regards to timeframes, after a lump sum bill is provided, a client has 30 days in which to request an itemised invoice. And after that request is made, the legislation says that you must provide an itemised invoice within 21 days. Now, that is a bit of a strange item within the legislation, because obviously after that 21 days is up, you don't forego your right to recover costs. And generally, as a rule, courts, you still have the right to obviously seek enforcement of your invoice in the local courts or the Supreme Court if it is relevant. But there is a general reluctance by the courts to deal with any kind of assessment. So they will generally throw that out and say, no, you must get your costs assessed. And that leads me nicely onto the last point. Make sure that you don't let that 12 months run from when you provide the itemised invoice. So the rule is you have 12 months from the date of the invoice to seek an assessment. Beyond that time frame, what the uniform law says is that either the client or the cost assessor can allow those costs to be assessed outside of the 12 months time frame, but that is an application by the client or the cost assessor. So where you find yourself, and I've been instructed by one law firm within the last 12 months who find themselves between a rock and a hard place, in that they've let that 12 months go by, and there's also clear cost disclosure issues in relation to the invoices that have been provided. They've tried to get enforcement in the courts, and the courts have said, we're not approving these invoices because of the cost disclosure issue. You need to take it back to the manager cost assessment. But when we tried to actually seek assessment of those costs, the manager cost assessment said that, well, you're outside the 12-month time frame, so it needs to be the cost assessor or the client. So again, as I say, just don't let the 12 months run unless you're absolutely certain that you can take the invoice to the court and the court will be happy with that. But as I say, the court will always lean on the side of trying to get the costs assessed if there is any ambiguity. And just again, in relation to lump sum and itemised bills, if you do send a lump sum bill out, you can include a reservation clause in the lump sum bill saying that if you do request an itemised bill and say, for example, you instruct an external cost firm to prepare the itemised bill and that amount is higher than the lump sum, we reserve the right to charge that higher amount. There was case law prior to the introduction of the Uniform General Rules on that point, which approved that that was okay to do, and then it was enshrined into the Uniform General Rules. I think there is validity in having that, because obviously the lump sum, I would say 95% of my law firm clients charge less than the work they've actually undertaken in relation to a lump sum invoice, because they're always erring on the side of caution. And obviously, if you do then go to the lump sum, the itemised bill, and find that there are more costs involved, and you've obviously had to incur the cost of having that itemised bill prepared, then there really shouldn't be any reason why you shouldn't be able to charge the higher amount. Now, obviously, That doesn't go behind the rule of you can never charge your client for the work undertaken in relation to itemising that bill. But if you do obviously find additional costs, then those costs can be charged to the client. Okay, on to cost disclosure. I've just included the basic rules surrounding it. I'm only touching upon the cost disclosure rules in relation to the uniform law. As you may know, that the Legal Profession Act applied prior to July 15. The rules are slightly different, but I would say as a general rule, the uniform law made the cost disclosure requirements more onerous for law firms. And these are the basic requirements. So you must set out the basis upon which the legal costs will be calculated and provide an estimate of the total legal costs. Now, what a lot of law firms fall down on is they provide a range as to the total legal costs. So, and that range is often based upon the damages that you might be seeking to recover. And there are cost assessors that say, if only a range has been provided, that is in inadequate cost disclosure. What you should also have just after that range is an inclusion of just what you believe the total legal costs will be. So that's, it can be worst case scenario, it could be total counsel's fees, but it needs to be, sorry, not could be total counsel's fees, it needs to be the totality of all of the costs in one clear sentence. Otherwise, as I say, I found, I was involved in one assessment in, I think it was about 6 months ago. There is one assessor that said a range was okay in regards to the uniform law. I'm not too sure that that's correct. But the majority, as I've seen it, would say that if you don't provide a total estimate, then that is inadequate. In terms of when cost disclosure must be provided, the legislation says when or as soon as practicable after instructions are initially given. That's essentially been interpreted as within days of formal instructions being received. I had a matter a couple of years ago where cost disclosure was provided 14 days later, and the assessor said that that was insufficient. So again, bear that in mind. And yeah, that's just a point in terms of saying that the rules surrounding cost disclosure under the Uniform Law are slightly more onerous than under the Legal Profession Act. Just a point on the client's consent and understanding. I could probably do almost an entire CLE on this point alone in terms of what all reasonable steps means in this regard. But I say the legislation there obviously says all reasonable steps. What I've found a lot of the time is that if you've set it out in writing and there's also a clear telephone call with the client where you've gone over the scope of the cost agreement, the scope of the work that's to be undertaken, and you've made sure that the client's actually understood what is going on, what they're going to be charged for, and what the work is that's going to be undertaken. That kind of belt and braces approach should, I would say in the majority of circumstances, mean that you've satisfied this section. And again, this should be done as soon as there's that first meeting. So you could have that attendance note prepared out while the client's sitting next to you, just to make sure that there is compliance in that regard. Just a point on the significant change. So anything that's previously disclosed, if that's if there has been a significant change, I think in practice usually that's if you're expecting costs to be a lot higher, or the work that you're going to do has changed drastically, then an updated disclosure needs to be provided. I say as a general rule, just review your cost disclosure position every 3 months with cases. And again, that's very easily said than done, particularly from a cost lawyer saying that, because in practice, reviewing all of your cases every 3 months is incredibly difficult to do. But try and do it as periodically as you can. And if you notice that there is something unexpected happen in the case that you didn't previously expect happening, then just give consideration to cost disclosure. Do we have a question? Okay, so Jennifer's asked, what if no or minimal work is done in those 14 days? This is a question I actually get asked a lot, and it really reflects the fact that the legislation doesn't really reflect what happens in practice, because client will come in, say, I don't know who the defendant is, I know that I might have a case, I know this person might have said this, it could be in a PI matter, the client's got injuries, but it's obviously only days after an accident has occurred. So what I would suggest in that situation is really to stage the cost disclosure as best you can. So that initial disclosure that you send out, you can say to the client, based on the information to hand, I will need to do this fact-finding work and put a total estimate of the costs for that kind of scope of work, and then confirm that an updated disclosure will be provided once a fuller picture has been obtained. So yeah, that's really the only thing I can suggest in that situation, just to kind of stage it, and then once you do have the full information, go from there. So this is moving more on to party assessments, but it does apply to an extent in relation to cost disclosure. I'll just quickly say the ramifications for a failure to provide adequate disclosure is that the cost agreement is void. So in practice, that means costs assessed on the basis of what are fair and reasonable. And again, I think in practice, it's really the same assessment as what would occur in relation to a party assessment. So to conceptualize it, just go back again to the original slide and those percentages that I pointed out in terms of what to expect in a solicitor client and a party assessment. But one of the other ramifications is that because the cost assessment is void, the hourly rates that you've included in there could be subject to a reduction. And I've included the CARC guideline rates just for a reference there, because they rarely get used in practice. Cost assessors in almost every assessment I see say that they're only a basic guide and they're not set in stone. They haven't been updated for a number of years, and they are not bound by them. And they really just on that, from then on, really go to what they consider to be reasonable. I'm reluctant to put a mathematical figure on it, but I would say in relation to the ranges, obviously the ranges are reflective of the complexity of the matter, but nowadays I would probably add 15 to 20% onto those because it's been so long since they've been updated. We have another question. CARC stands for the Cost Assessment, I don't know actually, the Review Commission, I think. It's on the Supreme Court website. There's a CARC guideline. If you just tap that into Google, might be Review Committee, that's a bit embarrassing, but let's move on. So yeah, and just the last point there, we were instructed in relation to a construction matter about what I was a year ago, and we actually got an average of all of the council's rates within the Doyle's Guide, and as you can see, those rates are higher than the ranges provided on the CARC guideline. Well, the average is almost at the top end, so that gives you an idea of the level at which they're reviewed. All right, it's the Cost Assessment Rules Committee. Thank you, Fiona. I think I said Review Committee, so almost. Do you think acceptable hourly rates will go down now that people are working from home and overheads are lower? I very much doubt it, because certainly from the first point of view, there's not been a review since 2016, and the cost of living has gone up and up and up. And certainly there's no, from what I've heard, indication that the rates are due to go down. Okay, just moving on. So this again applies in relation to both solicitor client and party assessments. Costs are assessed on the basis of the 6-minute unit, and it's pretty much par for the course wherever you go. Okay, just another question regarding the filing fee on cost assessment before a grant of probate is provided. Settlement is a half reasonable. I'm not really too sure on what that question is, but the filing fee for cost assessment is always 1% of the costs claimed, if that helps. Okay. So just a point on mediation, there is a common misconception that each party will bear their own costs, but that's not actually true. The Civil Procedure Act says that if the mediation was in the course of the proceedings, then the successful party should be able to cover the cost of the mediation. The common misconception in relation to mediation, I've had some clients think that each party will always bear their own costs on a party-by-party basis, but if it's been ordered by the court, or if it's from a common sense point of view in the course of the proceedings, then you should be able to include that within your party-party bill of costs. So just the final few slides now. So as I say, this is a recent determination my firm were instructed in. I was instructed by a law firm who were instructed by the liquidators of another law firm. So it was almost like an Inception type situation. But what had happened was a law firm had been liquidated. The partner of the law firm had then gone to another firm that he'd set up, taken all of the clients to that second firm and said, I think we should challenge the costs that I had incurred as a liquidator of that firm. And so we had a few matters brought to a cost assessment. Obviously, the first argument I raised was that there was a conflict of interest, because this lawyer, now acting on behalf of the clients in the new firm, was doing the work for the liquidated firm and was principal of that firm at the time. And there's also a rule that, and these are probably in the more extreme circumstances, that if you fail to provide adequate cost disclosure, then the principal of that firm could be liable for having committed professional misconduct. And I haven't really looked into cases on that, because that's more of an OLSC point. But I think that would have to be the real kind of extreme cases. So probably more in relation to quantity, or kind of more deceptive conduct, which is what my opponent was actually arguing, strangely, because he was arguing that he himself had committed deceptive conduct. But anyway, so the argument there was that the cost agreement was void. That cost should be assessed at nil because there was no retainer, which is a separate question to the cost agreement. Because obviously, if the cost agreement isn't valid, that doesn't necessarily mean there's no retainer. So we were unsuccessful on the cost disclosure point. So as I said earlier, that means that the costs were assessed on the basis of what were fair and reasonable. And we still got a pretty good result. So we managed to get 83% of the costs as claimed. And as I say, just going back to those percentages, we would have broadly expected somewhere between 60 to 75% based on the reasonableness of the cost claims. Just got another question. What's the difference between retainer and cost disclosure? So a retainer, I would say, is just the basic contract that you have with the client. It can be written or oral, but that is a retainer that the client has agreed to retain you to undertake work. A written cost agreement is what I would say in all situations you should provide, even if there is an implied retainer. So if the client kind of instructs you by, or if you have a retainer by the client instructing you, if that makes sense. But so I wouldn't necessarily use them interchangeably, the retainer and the cost agreement. But then obviously within the cost agreement, then you have to provide adequate cost disclosure. And those are the rules that I referred to earlier in relation to making sure that you've set out the scope of the case and the total costs that are going to be charged. And you'll need to go through that with the client. So they are quite confusing terms in some ways, but and there is some overlap, but just try in every case to make sure that you provide a written cost agreement, because it's just better practice to do so than otherwise not doing it. So yeah, as I say, we managed to get quite a good result on that. Just some of the points that were mentioned were that, so the argument was put forward that costs claimed prior to the date of the cost agreement are not recoverable, but we managed to say that, again, there was an implied retainer. So the client had given instructions. So even though the cost agreement wasn't in place, there was an agreement for the law firm to do work and charge for it. Hourly rates, as I say, they were subject to a reduction, but we managed to argue that they were reasonable. A lot of the work was done by a paralegal at $220 an hour. For a case of this complexity, I would have expected a reduction, but we argued that there was a good level of delegation, so we managed to get those costs as claimed. This was a PI matter, and the defendant was a nominal defendant. So that means that the other driver wasn't actually identified, and the cost assessor made the point that these types of cases are always more complex than where the other driver is identified. And I think that extends to a range of cases. So if the defendant is difficult to track down, or I think it even extends to just general intransigence from your opponent. If they're causing costs to increase unnecessarily, then I think that will inevitably cause more work to be done, both from a solicitor client and a party point of view. So that's just something to bear in mind. So moving on to the recent review panel determination. As I say, this is very recent. So the review decision was provided on the 19th of October. For those of you that don't know, so a review panel is, in the most basic terms, an appeal from a cost determination. So you go through a cost assessment, a cost assessor will provide their determination. But in this case, what had happened was that the receiving party, so I was instructed by the paying party to prepare the review application, but the receiving party had not put my instructing law firm's details onto the application for assessment. So that effectively meant that the paying party was unaware of the assessment going on. So the bill of costs was served on the lay client. It was at their generic company address, so it just got kind of lost in the mix of those info at email addresses. So the cost assessor, because they didn't receive a notice of objection, because we weren't aware of it, essentially assessed the costs almost as claimed. I think the costs claimed were about 225k, so 222,000 was allowed. And that really goes to making sure that you do have a notice of objection filed if you're the receiving party, and also obviously submissions filed if you get asked by an assessor in a determination. Sorry, I should say in a cost assessment process. But we filed a review application. And just a point on filing a review application after you've received the determination, there is a hard time frame of 30 days from the date the determination is sent to the parties. So beyond that, there is in the legislation a provision that says the manager cost assessment will consider an application for review beyond the 30-day time frame, but in practice, I've never seen one that gets approved beyond those 30 days. So whenever you get a cost determination, make sure that firstly, you're happy with it and you're happy with the amount. Obviously, if you're paying party, if you're happy that there's a significant level of a reduction, or if you're receiving party, if you've got a high percentage, certainly if you get one in the sort of 80s percentage wise, then that's a good result, usually on any stretch, either a solicitor client or party. But we filed the review application within the 30 days. Because of the issue with not including the details of the parties, we were allowed to file a fully itemised notice of objection, and the review panel, so the review panel are also cost assessors, and it's just a panel of 2 assessors who are different from the cost assessor that undertook the actual determination. But the review panel reduced the cost by almost $100,000, which again was a good result because, sorry about that background noise, I'm not too sure what that is, but I'll muddle on through. So usually with a review panel, the aim is to make a difference of at least 15%. So depending on if you're filing for receiving or paying party, if you get a difference of at least 15% from what you're seeking from the original determination, then the cost of the review panel will be paid by your opponent, as well as the filing fee for the review application. And generally, I think the cost of the review, so my firm's cost, should be recoverable from the other side. But that's a point that we're actually seeking to appeal, which I'll come on to in the next slide. But obviously a clear issue here was that our opposing party failed to include the instruction lawyer's details in the application for assessment, meaning that we never received it. I don't know if you can see that from the slides, but that's a key issue in all cost assessments, is that a cost assessor will always include within their determination that they've given both sides the opportunity to respond pursuant to Section 69 of the Uniform Law Application Act. And in practice, what that means is that from a party point of view, a draft application gets sent to the other side, the application for assessment, I should say, gets sent to the other side. What the rules say is that the paying party must provide a notice of objection within 21 days. If they don't, then the party filing the application will file an application for assessment. And then what happens is a cost assessor gets appointed. That cost assessor then provides their own directions to say, by this date, I'd like a notice of objection, and by this date, I'd like submissions from the other side. So I would say usually that 21-day rule is a bit of a fallacy in relation to party proceedings. In relation to solicitor client, there is a similar rule, but there's no sending the draft application for assessment prior to actually lodging it. But the cost assessor will always make sure that they've given all parties ample opportunities in which to respond. In this case, the receiving party was one of the defendants in the substantive proceedings. There were 2 defendants. Effectively, we were acting on behalf of a healthcare provider, and these 2 defendants were former employees who had left the healthcare provider. One of them had taken confidential information with a view to starting up their own competitor. My instructing law firm got an injunction very early on to essentially saying, we think you've siphoned off all of this confidential information onto this USB. An injunction was obtained to say, do not delete anything from that. If you do, you'll be found in contempt of court. That defendant, notwithstanding that order, did then delete the information, was found in contempt of court, and obviously lost the case because it was very clear that they had breached their contract of employment. The other defendant in relation to the proceedings was also included, but I think from what I saw that it was just ultimately found that there was no point pursuing this defendant. They'd moved to a different jurisdiction and was not operating in the same kind of competing space. So a notice of discontinuance was filed, which not as an automatic rule, but usually the basic rule when if you file a notice of discontinuance, the other side has a fair likelihood of recovering their costs of the proceedings. So the reason why I gave that background is just to say that there were quite a substantial amount of common costs that the opposing law firm had undertaken in relation to both defendants. What the review panel said was that rather than looking at each individual item and saying, well, this one looks like it's 20% in relation to D1, 80% in relation to D2, what they applied was what's called the rule of thumb. So any common costs, they would just provide an overall percentage. Again, some cost assessors just completely disagree with this approach and say, I'm going to assess them on an item by item basis because it's too blunt an object to use. But in this situation, they did and applied a 50% apportionment to all of those common costs. And as I said earlier, travel time was reduced to half hourly rates. You're always going to get that in a party-party assessment. And so the opposing party was ordered to meet the costs of it should be the review, because technically the assessment, well, that's the actual competing issue here. So the cost of the review, from the review panel's point of view, included the review panel's costs and the filing fee. But what they believed in their review panel determination was that they didn't have the power to order the other side to pay our costs of the review because of the wording of Section 88 of the Uniform Law Application Act. And what the Uniform Law Application Act is basically says that the review panel, aside from the actual assessment of the costs, can make an order in relation to the review panel's costs and the filing fee. In my view, the review panel have wrongly interpreted that as an exhaustive list of things that they can award. And what the review panel said is we don't have the power to order one party to pay the other. So, as I say, an appeal, we lodged a summons yesterday seeking leave to appeal this point, because the costs were quite substantial, because the other side had really put us to task on a lot of issues. Even after my application for review was filed and the notice of objection was filed, they countered with arguments that, in my view, were had no kind of legal basis in costs to argue, and that in turn required me to provide further submissions rebutting that. So the costs are quite substantial, and I'm hoping we'll get leave to appeal that, and we'll have a decision in the new year, because there is often ambiguity in terms of recovering the costs of an assessment aside from the actual cost claimed within the bill. And I think certainly in New South Wales there should be clearer rules surrounding that. So watch this space. And just a point on interest, this was one of the arguments that I thought was just ridiculous to press. So the other side wrongly included interest within their application for assessment. Proceedings had been issued prior to 24 November 15. What that means is, if you've got a case where proceedings are issued prior to that date and the order is silent as to interest, and I mean the cost order, that is, the cost order doesn't have the power to order one party to pay interest, or the paying party to pay interest, I should say. If proceedings are issued after 24 November 15 and the order is silent as to interest, the cost assessor can award interest, and invariably does. And it's pretty clear that the Civil Procedure Act is quite clear on this point. So again, it shouldn't have been an argument that should have been run. The argument was that because proceedings were issued after the introduction of the uniform law, So it fell between July and November 15. I can't remember the exact wording, but it was something like the spirit of the uniform law should say that interest should be payable, whereas it's a legislative provision and it's just a binary question. So just to recap, I know that, as I said at the beginning, I'm probably talking to lawyers with varying levels of expertise in costs and experience. Happy for you to shoot any questions at me, drop me an email. I'll provide my contact details on the next slide. I think I've got another question. Okay, what would happen if the client never signed the cost agreement, but you started the work anyway? Or if you've lost the signed cost agreement? I think that almost comes down to an evidential question. I shouldn't use evidential in that context in relation to the cost assessment, because the rules of evidence don't apply in relation to a cost assessment. But I think if there's an implied agreement that the client has agreed the terms of the cost agreement, then I think you should be okay in terms of arguing that is a valid cost agreement. Particularly, as I said earlier, if you've got a telephone attendance where you've gone through the cost agreement with the client, then that's much more clearer evidence in terms of saying that the client has given their consent to the cost agreement. So it's certainly not an absolute requirement for the cost agreement to be signed, but it's obviously better practice. But if it's not, then I would have a look at it, and if it's clear that the client has given their consent, then you should argue that the cost agreement is still valid. So yeah, just a summary on time recording. I think that the two key things to take away from today are: make sure your cost disclosure is okay. So have a look at a few of your cases now, because I'd probably estimate, when I get instructed in a solicitor client matter, about 50% of the time there's an issue in relation to disclosure. And secondly, just time recording. So make sure that the work you're doing is progressive to the claim, and that's clear in relation to the file note that you're preparing. Try not to repeat certain phrases too often. Make sure that the work is of use and service to the claim, and that it's relevant to the claim. And I always say that if the work can be attributed to the other side's acts or omissions, make sure that's made clear within the attendance note. And equally, if you're only ever going to go to a solicitor client assessment, so if you don't do contentious work and you're never going to get a cost order, if the client's causing you to do more work through their instructions, then make it clear from the file note that that is the reason for you doing additional work, so that if you do come to do an itemised bill, then you can look back on it and say, this is the reason why this additional work was undertaken. And usually, I'd say the minority of cases, a cost assessor will actually look at your file notes. There are some assessors that will do it almost in every single situation, but it certainly helps to keep good time recording, even in cases where you're charging a fixed fee, because it reflects the fair and reasonable costs that have been incurred. So that brings me to the end. I'll just exit out of this. So I'll just put my contact details at the end. So yeah, as I say, I know that it's difficult to cover all of these topics within an hour. And again, as I say, I've tried to focus on the points that I think really helps practitioners on the front line as much as possible, but always happy to field any questions that you may have. So yeah, just by all means, drop me an email or give me a call. So on that note, are there any final questions on anything I've discussed, or any other cost issue that anyone might have?
Hi, everyone. I think sometimes the cost agreements are they get a bit long for regular clients to have to digest. Have there been any findings where they've just gone, you know what, this was too complicated for a layperson to read and understand?
So I wouldn't say specifically on that, but then it goes back to the point of whether or not you've actually got the client's consent and understanding. And as long as the law firm has taken all reasonable steps, so that's an objective question. But it's obviously, as in all areas of law, it's open to interpretation. But if you feel like you've taken all reasonable steps to make sure that the client's understood all of the cost agreement, then that's okay. Now, the longer the cost agreement, the more likely, or the less likely the client's going to have understood it. So I think you're probably right in saying that the longer the cost agreement, the more likely you are to opening up the possibility of a cost assessor saying that, well, there's no way that the client could have understood that because it's just too difficult. But on the flip side, if you've got under the heading where you say scope of the agreement, if you've just got a quick bit to say, I guess it actually, if you've got something to say it covers everything, and this is the total, then from the assessment point of view, that should be okay. But from the client point of view, that might cause a bit of a problem in practice if you haven't really set out what it is that you're going to do. And they might bulk at the block figure if they're not actually being told the exact work that's undertaken. So that's probably not a very helpful answer because it's sitting on the fence, but it's difficult to get that sweet spot right. So I think that the best I can say is just go back to the telephone attendance note to say that, or the in-person note to say that you've gone through it with the client. So you could even have copied the bits of the cost agreement into the telephone attendance note and put the client has understood this, I've gone over this, this and this, and then it'll be a lot clearer that the client's consent has been obtained. Yeah, I hope that was informative for everyone. And yeah, like I say, if you have any questions after this, drop me an email.
Thanks very much, Joe, and thank you especially for taking the time out of your holiday away in Byron Bay. We're all a little bit jealous, but we do definitely appreciate you walking in for the beach for us.
No worries at all. It was great to meet everyone, and yeah, I'll no doubt speak to you guys soon.
Sounds fantastic. Thanks, everyone. And just a reminder that the next one will be on the 8th of December. So we'll send an email out about that shortly. And until then, look after yourselves and keep well.
Thanks, everyone.
Thanks, guys. Bye.
Thank you. Bye.
Thanks, Jennifer. Thanks, Joe.